This letter is dated March 13, 2013, where South Carolina Department of Employment Workforce falsely accused me of being an harasser. Also instructed me not to have any contact with the agency to seek employment. And they also made threats of contacting a local law enforcement authority regarding the harassment. This was an attempt by the South Carolina Department of Employment Workforce to cover up civil rights violations. I did not harass anyone, and South Carolina Department of Employment Workforce has never filed charges with any law enforcement authority because it was not true. But this is what many employees will do. When they have done wrong, they will try to make the victim the violator to escape accountability. And this is what the South Carolina Department of Employment Workforce did unto me. This next letter is dated July 25th, 2013 from South Carolina Department of Employment Workforce, stating they had to be notified that bar from applying was applied to my master applicant profile. How do you have to be notified about something that your agency did with permission? And how do you have to be notified by me of this error? This was an attempted cover-up by South Carolina Department of Employment Workforce. It was an intentional lie sent to me. It was an intentional lie sent to the United States Equal Employment Opportunity Commission to impede a civil rights investigation into civil rights violation. So this was an attempted cover-up in which the state of South Carolina conspired with the United States Equal Employment Opportunity Commission to deny those civil rights violations. Bar from applying was applied on July 19, 2013, not to expire until December 30, 2018. But in reality, I believe bar from applying started long before that. This letter is from Martin E. Bell of the United States Equal Employment Opportunity Commission, Fuels Program, Washington, D.C. I blackened out some statement because they only put you in the weeds. But I want to focus your attention to the very bottom statement, which was discovered about 2 weeks ago. The reason why Martin E. Bell made this statement, because he pathetically and corruptly sought to excuse the behavior and the civil rights violation by the state of South Carolina. In April 1st, 2015, I received a packet of documents showing government officials of South Carolina of inter-office communication trying to cover up and deny bar from applying of employment discrimination and retaliation. And so when I received those documents, I filed an additional complaint with those evidence. And this is why he made that statement, because he refused to acknowledge those complaints and that evidence to excuse the civil rights violation committed by the state of South Carolina. The next page is some additional statement from Martin E. Bell showing how he pathetically and corruptly tried to excuse the civil rights violation committed by the state of South Carolina. The next page, I want you to focus your attention to the second paragraph, where he stated that the state of South Carolina sent me on interviews in May and July of 2013. Now, in the beginning, I showed you a letter showing that the state of South Carolina accused me of being an harasser and not to have any contact with the agencies to seek employment. So why would you send me on interviews in May and July of 2013 based on all that you'd accuse me of if it was true? It was not true. But this was an attempted cover-up by South Carolina Department of Employment Workforce because prior allegations had been made regarding employment discrimination and retaliation. and for the United States Equal Employment Opportunity Commission to use this against me when they had the documents and the evidence to show that the conduct of the state of South Carolina was not true, but they sided with them anyhow. The next page, I want you to focus to the very bottom that's been highlighted. The United States Equal Employment Opportunity Commission had the evidence, had the admission of guilt, but still chose to ignore facts and admission to deny civil rights violation of employment discrimination and retaliation. Mr. Ebell's statement goes on to read as such: with regard to South Carolina due changing your employment status to bar from applying on July 19, 2013, the evidence shows respondent identified does not meet minimum qualification as a reason for his action. This was a fraudulent statement. I have a Bachelor of Science degree from South Carolina State University and many years of professional work experience, so I was well qualified for the position that I was seeking. So here again, a fraudulent statement. South Carolina do also produce evidence establishing it did not realize its bar would apply to all other South Carolina agencies. Here again, an admission of guilt of applying a legal bar. But remember, I showed you a letter on July 25th, 2013, where South Carolina Department of Employment Workforce sent me a letter stating that bar from applying was a system error, and they had to be notified of that system error. But here's an admission of guilt of applying an illegal bar to deny me the opportunity to obtain employment. But with these facts, the United States Equal Employment Opportunity Commission chose to ignore facts and written evidence to conspire with the state of South Carolina to deny civil rights violation. I'm going to show you this next page as verification of my communication with Martin Ebell. To the United States Department of Justice, justice has been denied, justice is still required. And to the United States Department of Justice, I am requesting an investigation into civil rights violation committed by the state of South Carolina and the conspiracy of the state of South Carolina and the United States Equal Employment Opportunity Commission. Justice is still required.